Sure. Good evening, everyone. Good to see you. Just by way of quick introduction, my name is Kevin Nash. I'm the Deputy Registrar and Second Director of SIC. So I will be giving an introduction to SIC arbitration in Singapore, and the overall dispute resolution ecosystem.
My name is Tatiana Gurchkova. I'm Senior International Case Counsel with the Asian International Arbitration Center. Previously was Kuala Lumpur Regional Center for Arbitration. So I'll be introducing you to the arbitration practice and how arbitration works in Malaysia and why it may be interesting for you and probably developing your careers in the future. Okay, so I should go first. Each of us has about 40 minutes to present. And please feel free to interrupt us if you have any questions. Okay, so when I was working on the slides, I was thinking how to introduce you to Malaysia, basically. How much do you know about Malaysia and basically about all the transactions between Malaysian and Russian companies, what's going on the landscape between both countries. And this is a brief introduction. Basically, last year it was a very important year for both countries, Malaysia and Russia, as we were celebrating 50 years of diplomatic relations. There were some official celebrations in Malaysia as well as in Russia. Also, the bilateral trade and the interest from Malaysian and Russian businesses grows annually. As you can see on the slide, in 2016, Russia's trade with Malaysia increased significantly. Can you hear me better now? So as you can see, the trade between Malaysia and Russia increased, and therefore we expect probably more disputes to occur on this landscape between these countries. Also, one of the important milestones was in 2015 when the Russian-Malaysian Joint Commission was established, and in particular, this commission is supported by the Russia and Malaysia Business Council, which works quite actively currently. They organize different events for business communities in Malaysia and in Russia. There's a new representative who was recently elected. And according to the chairman of this business council, also they expect more investment projects, about 100 plus investment projects from Russia to Malaysia. And yeah, just one of the interesting milestones is that the first Malaysian astronaut was also supported by Russia, and he traveled to the International Space Station supported by the Russian government in 2007. Malaysia is predominantly a Muslim country, and that's why there are close ties with Tatarstan, with the Tatar Republic here. For instance, last week we had a visit of the president of Tatarstan, Rustam Americanov, to Malaysia. If you heard about Innopolis in Tatarstan, they actively developed these high-tech projects in Tatarstan. So this idea was actually borrowed from Malaysia. One of the states, Johor Bahru, which actually is on the border with Singapore, so they also developed high-tech projects, and the president of Tatarstan decided to establish a similar initiative in Tatarstan. The other areas of cooperation include oil production, oil processing, engineering, construction materials. By the way, majority of the disputes we're handling, they're construction disputes because Malaysia is developing very quickly, and most of the disputes they of course relate to construction of oil and gas and construction, and oil and gas and maritime construction. When it comes to collaboration in the area of arbitration, as you can see here, we signed the MOU with the Russian Arbitration Association. On the right, you can see the director of the AIC, that's Professor Sundaraju. On the left, Vladimir Paley, who is now a partner of Baker McKenzie and also a chairperson of the Russian Arbitration Association. We work in 8 different languages, and our team currently legal team consists of 14 lawyers. When I joined 2.5 years ago, we were only 4 people, and because of the growth of the caseload, we need more and more. So currently we have 2 Russian speakers. We recently hired 1 more Russian speaker. This is when it comes to arbitration. Yeah, and of course our arbitration rules are available in Russian. Briefly about the history of arbitration in Malaysia. Basically, back in 1957, Malaysia became a member of the United Nations and the United Nations Commission on the International Trade Law. Also, Malaysia adopted the model law in its legal system. Signed the New York Convention. Have you ever heard about the New York Convention and the importance of the New York Convention?
Of course.
Yeah. Can you briefly introduce us? Why is it important to be a signatory to the New York Convention?
Well, it's important because the New York Convention allows you to enforce and recognize an arbitral decision in any country of the world which signed the New York.
Country.
Well, in fact, the vast majority of countries signed and ratified this convention. So theoretically, you can enforce this in all those countries which ratified it.
Correct. I actually was doing some research about the enforcement of Russian words in Malaysia, and I'll mention later. I found one word, Russian word, enforced in Malaysia in 2012, if I'm not mistaken. So yeah, basically New York Convention is one of the most successful conventions which exist nowadays. It allows to enforce foreign arbitral awards, and it was initiated, basically the process to draft this convention. It was initiated after the Second World War, because relations between the countries were kind of hostile, and there should be a mechanism, basically, it should have been a mechanism to encourage international trade. That's why United Nations came up with a proposal to draft model law, then also arbitration rules, and then New York Convention. Actually, it was the idea of Syria, if I'm not mistaken. And then the Arbitration Act in Malaysia was enacted initially in 2005, and the first wave of amendments was in 2011, and the second wave of amendments was earlier this year in May. And actually, our center was initiating these amendments in order to increase competitiveness of Malaysia and our center on the Asian and international landscape. And also, I forgot to mention, we changed our name this year. So this year, 2018, is also very remarkable for us, for the center, because we were established 40 years ago, so it's 40th anniversary for us. We were established on the basis of the international agreement between the government of Malaysia and the Asian and African Legal Consultative Organization back in 1978. At that time, it was important, basically the rationale behind the creation of this institution was that to keep international and domestic disputes in the country, within the country. And this Asian and African Legal Consultative Organization established 5 institutions all over the world. For instance, the other one in Egypt, in Tehran, in Iran. But our center was the very first one. So it's the oldest one and one of the oldest institutions in Asia. So what makes the jurisdiction attractive to arbitrate in? Of course, it should be friendly judiciary, actually, which is pro-enforcement, basically, which makes the jurisdiction itself so-called friendly for the enforcement of foreign arbitral awards. As I mentioned, this is the case, the Russian case, which was enforced in Malaysia in 2011. Also, I already mentioned New York Convention, provisions of it's important that provisions of the Arbitration Act actually in line with the recent amendments of the, let's say, institutional model law and the most modern arbitration acts all over the world, such as UK or New Zealand arbitration acts, or regional arbitration acts such as Hong Kong and Singapore. So 2018 amendments to the Malaysian Arbitration Act, basically one of the rationales, as I mentioned, was to reflect the amendments of Institutional Model Law in 2006, because previously the Arbitration Act was based on the Institutional Model Law 1985, so it was kind of outdated. And then the second rationale behind the amendments was to increase regional competitiveness of Malaysia, so that parties will be interested in Malaysia as a center. For instance, Section 3A of the Malaysian Arbitration Act was changed in a way that now it's not necessary to have a legal background to represent the parties in arbitration. For instance, if it's a complex construction dispute and you have an engineer who has experience in arbitration, he or she may represent the parties to arbitration seated in Malaysia, or an architect or any other background, basically. Arbitrability, basically also the scope for arbitrability was expanded. Right now, if there is a dispute with regard to arbitrability, let's say we have a corporate dispute and parties previously were not certain whether they can arbitrate corporate disputes or not. So if there is a dispute with regard to arbitrability on the very initial stage, parties may go to court, the High Court in Kuala Lumpur, and address this issue. So if the High Court decides that this particular case is arbitrable, then they will be able to proceed. So it will be decided basically on a case-by-case basis to make it pro-arbitrable. Disclosure is, as you may know, that one of the advantages of arbitration is that it's confidential. If you go to court, third parties may be aware about the existence of the dispute, and so on and so forth. But in arbitration, confidentiality depends on the Arbitration Act applicable basically at the seat, and also the scope of the arbitration agreement itself. So the new amendments, they reflect, basically they state that even the existence of the dispute itself should be confidential. So previously, in one of the cases I was administering actually, one of the parties had to disclose to the third party the existence of the dispute, and then at some point it became public information, and parties were, one of the things that the other party responded was quite unhappy about it. So right now, if you commence arbitration under the new Arbitration Act, even the existence of the dispute should be confidential. So parties are bound with this obligation. Some other amendments, for instance, the most important amendments were repeal of sections 42 and 43 previously. If parties were not happy with, one of the parties was unhappy with the final award, it could go to the, again, High Court of Kuala Lumpur or any other competent court in the jurisdiction and to set aside based on the issues of law. So let's say if respondent is not happy about the interpretation of law given by the arbitral tribunal, the party could go to court and to reconsider basically the dispute based on the issues of law. Right now it's impossible, so it kind of adds up to the finality of arbitral awards in Malaysia. Also previously, there were some problems with applicable laws in Malaysia. There was a provision, default provision, for domestic disputes that if a dispute arises between the Malaysian companies, then they were not able to apply foreign law, not always. So after the amendments entered into force, this is possible. So if parties, let's say, want to apply Russian law in Malaysian dispute, they can do so, or English law, or anything else. The other problem was pre-award interest. As you may know, when parties ask for different kinds of reliefs, they always ask to calculate the interest. And previously, it was impossible to ask for the pre-award interest in arbitration suited in Malaysia. And then, after one of the cases decided by the federal courts, and the federal court granted, if I'm not mistaken, pre-award interest, or actually refused to grant pre-award interest, and it was kind of a rationale behind these amendments that we should bring this practice in line with the best international practices and allow parties to seek for the pre-award interest as well. Okay, so now I'm gonna talk about the institution itself. What is important for the arbitration? What are the advantages of arbitration compared to litigation?
Effectiveness and limited time of the arbitration itself. So,
what's the average length of litigation proceedings in Russia? Does anyone know?
6 years, 6 months, 6 months, year.
1 to 3 years. Is it efficient?
Concerning every instance, maybe, yeah.
Do you think it's efficient?
Yeah, because it's a guarantee for independence.
But let's look at the international landscape. Do we consider litigating in Russia or litigation in Russian court being time and cost efficient compared to, let's say, Asian countries or European countries or US? Do you have some, can you compare Russian litigation with some other countries?
Well, I don't know about Malaysia, but I know in India, such cases may drag for like 10 years. And it's very inefficient there to submit their dispute to litigation.
Yeah. In Italy, I think, if I'm not mistaken, the average length of litigation proceedings is 7 years. In Malaysia, it's actually surprisingly quite efficient, a year or a year and a half. So, of course, it's not the best maybe avenue to go through, but it's still probably compared to some countries it's efficient and it's workable, but compared to other countries it's not. But at the end of the day, when you go to court, you have a judgment. So how do you enforce the judgment? Let's say you're very happy, you had your client won in the litigation in Russian court. What do you do with the judgment to enforce it, let's say, in Hong Kong?
You go to the court in London and try to enforce the decision of Russian court.
But do you know if you have this right to go to the court in Hong Kong? Is there any...
Well, you should have a bilateral agreement between the countries.
Right. Okay. But in general, to enforce the judgment is much more complicated than enforcing an arbitral award, because we have a New York Convention, and it allows basically you can go to the courts of Hong Kong, register the award, and then enforce it. As opposed to the judgment, when you will have to go through a different and more complex procedure. So again, when we speak about arbitration, it's very important that the procedure you actually tailor-made for your client is cost and time efficient. And arbitral institution plays one of the most important roles in this, because especially when you select the rules of a particular arbitral institution to arbitrate under. So we made some data analysis a year ago, and we came up with these numbers, basically, that the average length of arbitration proceedings, both domestic and international, when you arbitrate under our rules, is about a year. The average cost of international arbitrations, meaning that the tribunal usually consists of 3 arbitrators, is about $53,000 US. And for administrative fees, it's also quite cheap compared to some other institutions worldwide. When it comes to facilities, parties, especially when it comes to big disputes, parties, they want to be comfortable with facilities. So our facilities, they are state-of-the-art facilities. We have the most modern equipment. You can imagine transcription services, so on and so forth. We're about to have hearings, 3 weeks of hearings in a very big case. So the parties reserved about 4 hearing rooms, and we have the second building also with 2 big rooms. Each of them fits about 50 participants in the hearing. So you can imagine more than 100 people will be involved in the hearing. And of course, that when they were selecting the institution and the facilities, they inquired information about it. When we speak about the increase of the caseload, so before 2012, this institution, AIC or KLRCA, was kind of unnoticed, and we had only 22 cases registered, if I'm not mistaken, under 12 or 22 maximum before 2012. And then the government and the ICO jointly decided to change the management of the institution, basically. So the current director, Dr. Professor Sumiraju, he was appointed as a director. He's very passionate about arbitration, and he changed everything. So since starting from 2012 or 2013 till nowadays, till 2018, we have 2,000 plus cases. It includes everything: arbitrations, adjudications, mediations, and domain name dispute resolution. We administer 4 different proceedings. On top of arbitration, there is another ADR procedure in Malaysia. It's called adjudication. It's a statutory procedure. It's different from arbitration in a way that you don't need to have a written agreement between the parties to commence this proceeding. And it's very similar to arbitration. You also appoint someone, an adjudicator, similar to a sole arbitrator, who will resolve your dispute. Based on the Act, this person usually has 45 working days to come up with his decision. But there are 3 prerequisites. Basically, you may apply this Act only to construction contracts. The disputes can be only a payment dispute, and the project site location should be only within the territory of Malaysia. But it's a very efficient procedure, and everyone is very happy about it. The only one problem is enforceability. Because the decision of the adjudicator is not final, and in order to make it binding upon the parties, you still need to go to court and convert it into the judgment. So we have arbitration, adjudication, mediation. We have our set of mediation rules as well. And recently, there was also an order of, I'm not sure if it was the Malaysian government or doesn't matter, one of the authorities basically providing that there are certain categories of construction disputes should be referred to mediation under the AIC mediation rules before they actually litigate the dispute. This is to encourage parties to disputes to use ADR procedures. As I mentioned, most of the disputes we're dealing with construction disputes. Also, we have some maritime disputes or maritime and oil and gas, for instance, building an oil and gas platform somewhere. Islamic finance disputes. We're expecting some disputes under the arbitration rules I will mention later. So these are the products, these are the sets of rules we have. Arbitration rules 2018. Arbitration rules 2018. Arbitration, it's a very unique set of rules. It's applicable to disputes arising out of contracts where the Sharia law is applicable. So the only one difference basically with the standard set of rules is that if there is an issue arising out of Sharia law and parties don't know how to, or arbitrators don't know how to interpret or decide this or that issue arising out of Sharia law, they can refer to a special Sharia council. Then the Sharia council comes back to the tribunal or the parties, and then will proceed with the arbitration further. Fast-track arbitration rules, also a new set of rules, we reviewed it earlier this year and launched it in May. There are two procedures possible under the 2018 rules, fast-track arbitration rules. One is when if you want to have a hearing, and the other one without the hearing, or so-called document-based arbitration. For instance, if both parties are agreeable that they don't want to have a hearing, and it's very simple, let's say payment dispute. They submit set of documents, so they exchange statement of claim, statement of defense with each other, pass it to the tribunal, all relevant documents, and the tribunal will decide based on the submitted documents. The procedure for the document-based, basically the time, even the timeline given to the arbitrators under the document-based, in the document-based arbitration is only 90 days. But if you want to have a hearing, it's a bit longer, it's 180 days. So in 180 days, under the fast-track arbitration rules, you can have a final word. This one I mentioned. Some key features of 2018 arbitration rules. We didn't have joinder previously. I'm not sure if you heard about joinder and consolidation, or if you know about the difference between the joinder and consolidation, but we can talk about it later. Sometimes it's important for the parties to consolidate or to join arbitral proceedings at the very initial stage, so that the arbitration itself, the dispute resolution process itself, will be more time and cost efficient. For instance, we allow the parties to apply for joinder even before the establishment of the tribunal to the director of the AIC. So for instance, if there is a need for the third party to join at the early stage, the interested party can apply to the director. He will consider basically on a case-by-case basis and decide whether the party can join or not. Later on, if the tribunal disagrees with this decision, it can be reconsidered. Also, we introduced a new step in the proceedings, technical review of awards. It's similar to the scrutiny of arbitral awards, which is done by the ICC, the International Chamber of Commerce, International Court of Arbitration under the ICC. It's a very, basically, also we introduced this measure to improve the quality of arbitral awards rendered in Malaysia. Just last week, I finalized the review of one of the first awards rendered under the 2017 arbitration rules. Technical review includes basically typographical errors, any types of calculations, I don't know, type of, everything you can imagine. Something not substantive, basically, something which doesn't affect the substantive part of the award. Also, we operate since last year in multiple currencies, not only in Malaysian ringgit, not only in US dollars, but also in Singaporean dollars, in Russian rubles even. So for our arbitration rules, I forgot to mention something. For our arbitration rules, we also received a very prestigious award by the Global Arbitration Review back in 2012. So the international arbitration community considered this set of rules as one of the best innovations a few years ago, and that's why we were receiving this award. Mediation rules I also mentioned, we amended them earlier this year. When it comes to the name change, so AIC, KLRC changed its name to the AIC at the end of February this year. Regardless of the name change, we will administer all arbitrations referred to us under the name of KLRC. Same when it comes to payments of the deposits, payment of registration fees, appointment fees, and so on. The other interesting thing we are testing right now is our new case management system. We applied so far only in adjudications, but it's very convenient for all case counsels. Basically, everything is automatic. Everything is fully digitalized. You don't need to even prepare a draft letter. It's already there in the system. We just need to double check everything to review before it's actually being sent out to the parties or adjudicators. On the later stage, we are planning to apply it in arbitrations and mediations too. Standard form contracts, also because Malaysia is construction based country, all the disputes are construction disputes. It's very important that at the stage of the conclusion of the contract, parties have a template, let's say template or standard form of the contract to follow. So AIC initiated this huge project about 2 years ago. So we selected about 15 people in the who were appointed to this drafting committee, and we came up with these 4 standard form contracts. So far they are tailor-made only for Malaysia, but later next year we are planning to expand them so that parties coming from outside of Malaysia, not only from Malaysia, will be able to use the standard form contracts when they enter to construction or subconstruction subcontracts in construction. There is a special website. It's called sfc.aic.world, if I'm not mistaken. So you can go to the website and download all these forms free of charge. Also, if you already negotiated all the terms of the contract, you can tailor-make it on the website immediately, select certain provisions or certain conditions, and it takes you maybe 15 to 20 minutes to tailor-make your contract, and you can print it out. Okay, so the second part of my presentation today is to speak about initiatives for young dispute resolution practitioners and students. About a year ago, we decided to establish Young Group under the auspices of the AIC, that time KLRC. Why? Why is it important to support young students, young lawyers interested in ADR and in arbitration. Why? Because the industry, the area of law is dominated by male, pale, and stale. That's why, and it's for many students and for many young practitioners, it's very hard to break through and not only to find their first job in arbitration, in international arbitration, somewhere far away from their home countries, but also to develop their careers. That's why all arbitration institutions all over the world, they're trying to support young, promising, basically dispute resolution lawyers. In Singapore, there is Young Singapore, Young SIAC. ICC, there is Young Arbitrators Forum under the ICC. In Hong Kong, there is HK45 under the Hong Kong International Arbitration Center. So that's why we decided to also give similar opportunities to Malaysian lawyers and Asian young lawyers as well. And we established a Young Practitioners Group, so-called AIC-YPG. So we have 3 aims: to provide, to promote, and to personalize, to provide equal access to everyone to knowledge and to network, basically, with foreign practitioners, with domestic practitioners, to provide, basically, we organize many events free of charge for young lawyers. Instead of paying, let's say, $300 for experienced practitioners, if you're a member of the group, you can just attend free of charge or receive this or that certificate free of charge. To promote ADR and to promote individuals who are members of the group, we provide speaking opportunities even for students. For instance, last year we also organized the first Asian conference for students and young practitioners. And best students, we selected, basically there was a selection process, we were selecting papers, best papers submitted by students from certain Asian institutions, from Indonesia, from Singapore, from Malaysia. And based on the, basically those who won the best submissions, they were also able to present in front of about 500 participants of the moods and practicing arbitrators. And to personalize it, when you subscribe to the group, you can select the area of interest, whether it's investor-state arbitration or maritime arbitration or mediation. So you will receive only information related to the area of your interest. These are some steps which were taken by us to establish the group. This is the current structure of the group. I'm one of the co-chairs of the group. We have 7 committees. Investor-state, maritime, you can see it here. Also last year we started appointing student representatives. So far we have student representatives in all Malaysian law schools, about 30 students, 2 students per law school. And this year and next year we're planning to appoint non-Malaysian student representatives. So if you're interested, I encourage you to apply or reach out to us. Probably you can represent us in Russia. Some statistics, so we have 1,200 plus members, coming from 34 jurisdictions. And from March 2017 to August 2018, we organized more than 80 events, not only in Kuala Lumpur, but in other Malaysian cities. Areas of interest when it comes to our members, most of them they're interested in commercial arbitration, and mediation committee is the second most popular one, adjudication, and unfortunately maritime arbitration is the least popular one. Sadly enough, because Malaysia is a maritime nation. So that's why this year and next year we're planning to organize more events about maritime arbitration and resolution of maritime disputes. This was one of the first collaborations with the other group, actually with Young SIAC, as you can see here. So we organized the workshop on the oral and written advocacy back in February 2017. And we had a full house, about 180 students and young practitioners participated. The other collaboration, the also successful one with ICC Young Arbitrators Forum, so we were basically answering questions on how to build careers in arbitration and international arbitration, where it's most complicated, sharing our experience, how we started, what was important, where this industry goes to, what's the direction it takes us to, and so on. Mooding workshop, because we also launched the pre-mood for the Villain this mood in Kuala Lumpur. We were coaching Malaysian students, 17 Malaysian teams, helping them out. That's why we also had this workshop. I also briefly mentioned about this conference. If you're interested in participating next year, please apply. I encourage you to do so. We also provide accommodation free of charge for all non-Malaysian students. Sometimes you even can find a sponsor interested in covering your flights. This is what happened with the team of Young University actually earlier this year. Ekaterina and Nina, they were sponsored by one of the law firms, Karelski, Shuk and Partner, right? Yeah, and then they were the first Russian team ever participated in the pre-mood in Kuala Lumpur. Yeah, just some other examples of some other events we organized this year. I also forgot to mention something. We organized events in different languages, in Spanish, in Russian, in Bahasa Malay, in Mandarin. So if you're interested in organizing something in Russian, of course, we'll be happy to do so, even remotely. The other interesting initiative in July this year was collaboration with some African young groups, because we are established under the auspices of the Asian and African Legal Consultative Organization. We decided to came up with this proposal and found some young groups from Africa, and they actually flew to Kuala Lumpur to speak about the development of arbitration and development of tailoring dispute resolution processes between African and Asian companies. And we had representatives of 5 different African countries in Kuala Lumpur. This is basically it about the YPG. We are currently doing a roadshow within Malaysia. We have been visiting all law schools. Probably you can also use this idea in Russia. I can see Sergey here, so probably you can just travel to different law schools and initially within Moscow and then outside of Moscow to promote your group and ADR in general, and probably this one. And the last part of my presentation, which I have to mention because it's also one of our great initiatives. We launched this pre-mood and it became so successful and so huge that we are already preparing for the next edition in March 2019. The first edition was in 2017, March 2017. We had about 30 teams from 15 countries, so it became the largest in Asia from the first attempt. And in March this year, we had 76 teams registered and 68 teams actually traveling to Malaysia to participate. So it's a great experience for you if you're interested in mooting. These are some numbers. This is the world map we prepare every year. Yeah, this is your team actually, you can see. This is Ekaterina, as you can see, and Renat. And Renat actually is joining us as an intern next month. That's about all. I also have to show you a very short video about pre-moods. And please, if you have any questions, ask.
Young practitioners and young people, students who are
about all. Thank you very much for your attention, and please let me know if you have any questions.
Well, thank you for your presentation. It's really great. I want to ask you about what the most popular disputes in a region. You said about the construction disputes and corporate, and what else? What is the most popular?
Number one is construction, administered by us. Number two is maritime. Number three is oil and gas.
Thank you.
What are your expectations for arbitration in Malaysia? What's the future of AIAC tournament?
Well, we hope that the future is bright. That's why we work so hard. We have our own niche. So of course, Singapore and Hong Kong, they are also very, very much developed jurisdictions, and Malaysia is a bit behind when it comes to the development, but it's due to certain economic and political circumstances, I would say. But still, so we have increase, as I mentioned, in the number of arbitrations and in adjudications. That's why we hired more legal counsels recently. The Arbitration Act was amended earlier this year, as I mentioned. Also, we started working closer with the judiciary For instance, we are planning to organize a training for the judiciary in Malaysia in collaboration with UNCITRAL. So also to improve the understanding and interaction between arbitration and litigation. So as an institution, we are trying to take as many measures, pro-arbitration measures as we can. But as you may know probably, it takes a few years for everyone, for disputing parties, for companies, for business community to realize the advantages of ATR and arbitration and to start incorporating arbitration clauses, whether it's AIC clause or any other clause, into their contracts. So let's see, we hope that the future is bringing more disputes to us, but yeah, let's see.
Hello. What is the main advantage of the arbitration in Malaysia in comparison with Europe? Do you mind? Thank you.
It's hard to say to compare with Europe because the competition between all jurisdictions is so tough nowadays. If you look at the way all the amendments and most recent like modern amendments to the arbitration acts and arbitration rules are being adopted, it's basically we are reading news every single day what's going on in these jurisdictions, what's going on in that jurisdictions. For instance, an institute of emergency arbitrators. A few years ago, we didn't have emergency arbitrators in our rules, and then after some jurisdictions presented this idea or reflected in the arbitration, institutions reflected in their arbitration rules, we decided that it's a good idea to implement in Malaysia too. So, for instance, 2018 set of arbitration rules also reflects an opportunity of the parties to request our institution to appoint an emergency arbitrator. But at the same time, there was a problem with enforcement of the awards of emergency arbitrators because it wasn't reflected in the Arbitration Act. So this year we initiated these amendments to the Arbitration Act so that the definition of the tribunal now includes emergency arbitrator, meaning that, so it's a very lengthy process, and the advantage is basically it's easier, much easier to enforce arbitral awards in Malaysia now than it was a few years ago. Judiciary is very much interested in pro-arbitration. Arbitration rules of the only one arbitral institution, AIC, they comply with the best international practices. What else? Foreign lawyers, they can represent interests of their clients in arbitration seated in Malaysia. You don't need to have a power of attorney. You don't need to be qualified as a Malaysian lawyer. Being a Russian lawyer, you can step into the arbitration seated in Malaysia and represent your parties. The only one disadvantage so far in Malaysia is that we don't have third-party funding. For instance, as Singapore represented or introduced third-party funding last year, Hong Kong introduced third-party funding. It's for those situations when claimant wants to commence arbitration but doesn't have enough money to do that. So legislation now allows, in Singapore and Hong Kong, allows third-party funders to be there to fund disputes, as opposed to Malaysian legislation, which doesn't reflect these provisions yet. We proposed to amend certain laws earlier this year so that third-party funding will be allowed in Malaysia, but so far it wasn't accepted. So let's see, maybe the next wave of revisions next year and next year will be able to reflect this.
Can you please share your personal experience? How did you start your career in international arbitration?
Sure. So I started practicing here in Moscow actually. In 2011, I spent about 1 year with the bank and then two and a half years with a consulting company, Dutch company. So we were involved in some disputes between European companies and Russian companies, or management of European companies and Russian companies. I was doing arbitration-related work, but not representing parties in arbitration. But when I was a student, I was always passionate about arbitration. I also did the move, and I was kind of thinking about making this move from Russia to somewhere else. So I decided to do my master's in the US. After I completed my master's in arbitration, I decided to explore Asia. It was back in 2014, and it was the period when everyone started discussing this possible shift from European seats such as London, Stockholm, Paris, Geneva to the Asian centers. So I applied for internships initially with the ICC, Hong Kong, HKIC, and also PLRCA at that time. And after maybe 6 to 7 months of waiting, I received 3 offers out of 3. So I've done all my internships, and then I just received a job offer from the EIC at some point. That's why I decided to settle down in Malaysia. Yeah, briefly.
Well, if nobody has any further questions, we invite Kevin Nash to give a speech. Kevin, you have the floor.
I'm going to do a very non-arbitration thing, and I'm going to stand. In arbitration, unlike litigation, everyone sits, but I'm going to stand at least until my legs get tired. So what I'm going to start by talking about is the environment for dispute resolution in Singapore. Because Singapore is bigger than just SIC arbitration. It's really been the creation of a landscape for dispute resolution. So you have the Singapore International Arbitration Center, SIC, for international arbitration. You have the Singapore International Mediation Center for international mediation. And now you have the Singapore International Commercial Court for international litigation. The idea in Singapore is that no matter what type of dispute you have, you can solve it on Singapore's shores. So Singapore, I think, is legendarily proactive in terms of developing itself as a jurisdiction. So it's done a lot of things sort of to create this environment for dispute resolution. So it adopted the Mastер-class model law similar to Malaysia, which is actually very important. If you look at the map and you look at Singapore and Malaysia, 2 countries, 2 common law countries surrounded by civil law jurisdictions. So one thing in Singapore, and I'm sure the same in Malaysia, at AIAC, we're always trying to make sure that the rules, legislation, accessible to both common law lawyers and civil law lawyers. So adopting the Mastер-class model law, this very familiar legislation, has been quite critical to the development of Singapore, and it was a notable departure from the UK Arbitration Act and the previous iterations of that, choosing to go the model law route. If you want to establish yourself as a seat of arbitration, you have to have the support of the judiciary. So if you choose Singapore as the legal seat, you then bring in the curial supervision of the courts. So if you need support during the arbitration, any related applications, if you're, say, want to appeal a decision on jurisdiction, whether positive or negative, if you need to go to court, you're going to be going to the Singapore court. So the attitude of the judiciary is very important. Singapore is quite unique because the composition of the judiciary is very interestingly populated with arbitration experts. So the Chief Justice of Singapore, Sundaresh Menon, former deputy chairman of SIC, very highly regarded arbitration practitioner before he went to the bench. There's a commercial list that hears these arbitration cases in the first instance, all populated by former arbitration experts, arbitrators, Senior Minister of State, Minister of Law, so within the Singapore government as well, all arbitration experts. So there's a really keen understanding of what the arbitral process needs. And what does arbitration need from the courts? Well, what it needs from the courts is it needs the courts to know when to support it and when to allow the arbitration process to flourish. So in Singapore, there is a judicial philosophy of maximum support and minimal intervention in the arbitral process. So it's a very pro-arbitration jurisdiction. Soft factors as well in terms of making it easy for parties to get to Singapore, for lawyers or non-lawyers to represent parties. So anyone can represent parties in SIC arbitrations. Arbitrators can fly in and fly out. You want to make it easy for foreign parties to get to Singapore. World-renowned facilities and services at Maxwell Chambers. In 2010, Singapore set up Maxwell Chambers, so it was the first purpose-built dispute resolution facility. So all kinds of arbitrations are being heard in Maxwell Chambers, not just SIC arbitrations. ICC now has case management in Singapore, so you have ICC arbitrations with a Singapore seat, or maybe not a Singapore seat, they just decide to hear it in Singapore. LCIA, ad hoc stuff, all of these arbitrations are being heard in Singapore. And this was a really big factor in establishing a culture of arbitration in Singapore. Before SIC really took off as one of the biggest institutions in the world, all of these cases were being heard in Singapore, so also big investment cases there. So we always thought that we had far and away the best hearing facility in the world. If you ever get the chance to go to Kuala Lumpur and see their facility, it is absolutely gorgeous. And I think maybe because of that, maybe not, we are now expanding Maxwell Chambers, so we're going to triple the size of Maxwell Chambers. They're moving all of the institutions next door. There's going to be 3 floors of hearing. I'm told that it's going to be the world's first smart hearing facility. There are robots. I'm not kidding, there are robots that will serve you food in Maxwell Chambers. Everything is automated, done through computers, so it just sort of goes to show how each of the jurisdictions are looking at each other, trying to have the newest and best, but both Singapore and Kuala Lumpur, beautiful facilities. In fact, SIC arbitrations, I'm quite sure, and you can confirm, I think some SIC arbitrations are actually heard in Kuala Lumpur from time to time, so SIC arbitration, Singapore seat, and they have them heard at KLRCA. The torts of champerty and maintenance have now been abolished in Singapore, as was discussed earlier, so there is now third-party funding for international arbitration and related proceedings. This is quite important for companies from a risk management perspective, also from an access to justice angle. So a lot of these third-party funders are now moving into Singapore, funding arbitrations, particularly because at SIC we're getting an increasing number of arbitrations involving states. Third-party funding is a really big factor in investor-state arbitration. So now you have this regime for third-party funding as well, which puts Singapore on par with many of the Western European jurisdictions. So you have the Singapore Supreme Court, this very pro-arbitration bench. What Singapore also has is the Singapore International Commercial Court. So in addition to some of the leading Singapore jurists, you also have judges from around the world that make up the Singapore International Commercial Court. I'm Canadian, so I was quite happy that our former Chief Justice is now on the Singapore International Commercial Court. So if you have an arbitration in Singapore and you need to set aside an award, review a jurisdictional decision, enforce an award, and you don't want to have it heard by the Singapore Supreme Court, you can make an application to have it heard by the Singapore International Commercial Court, this body of international jurists. So that's an attractive feature as well. So this is what we're talking about. This is Maxwell Chambers. This is where all of the hearings are going on in Singapore, and you have all of these administering institutions. By my count, I think Singapore, in terms of the major institutions, has the most international administering institutions of any jurisdiction. So there's a lot of activity happening at Maxwell Chambers, and it is set to expand. These are some of the rooms, because you can imagine in some of these big state cases, you might have 100 people in an arbitration, 150 people in an arbitration, so you need to have capacity for that, which both Singapore and Kuala Lumpur do in their hearing venues. So let's look at how SIC sort of fits into this dispute resolution mix in Singapore. SIC is kind of an interesting experiment because it's one of the younger institutions in the world, and now it's one of the biggest. In 2017, we had 452 new cases. Around 420 of those were fully administered by SIC. That means we're administering the case under the SIC rules or under the UNCITRAL rules. Very international caseload. More than 80% of our cases are international. We had parties from 58 jurisdictions last year. I think in the last 5 years, we've had parties from around 100 jurisdictions. So the penetration of SIC arbitration clauses, all 6 continents from countries all around the world. When you're looking at an institution, really, the way that an institution establishes itself is by establishing a track record of enforceability. So at the end of the arbitration, no matter how fast, no matter how cost effective, you are ultimately holding an award. These awards tend to be longer now, sometimes 100 pages, sometimes 500 pages, but you are holding an award and you have to do something with it. So we know about the New York Convention, 159 countries now, limited grounds to refuse enforcement, but you still are going to have to take this to a court. This needs to be portable if the parties aren't settling. So SIC has a very good reputation for enforcement, but it's not just the reputation for enforcement. I think it's the knowledge of the region, and I think that's what both Singapore and Kuala Lumpur have. For some of these institutions in Western Europe, so for instance, if you had a Russian party and an Indonesian party, Russian party's a claimant, gets a $100 million award from the Indonesian party. Council has looked at where are the assets from this Indonesian party. Do they have assets in UK, Singapore, Hong Kong, somewhere where it may be easy to enforce this award? They don't. All the assets are in Indonesia. So now what do? So if you're an Asian institution where you have all of these awards going to Indonesia, you know that the award needs to be registered at the Central District Court of Jakarta. If the tribunal does not issue a power of attorney so that the council can register the award, the tribunal may defunct this, no longer able to act, and now you have an award, and you really might not have something to do with it. So I think it's a knowledge of all of these procedural requirements in some of these emerging jurisdictions, which is tilting the axis of arbitration to the Asian institutions, Singapore, Kuala Lumpur, Hong Kong, because you have so many of these counterparties located in Asia. I think that this is only going to increase with the Belt and Road Initiative, so now you have an outflow of all of this Chinese investment really going all around the world, and where are those parties going to choose to solve their disputes? Likely going to be at these Asian institutions. In terms of case administration, effectively what you do, if you look at the chronology of an arbitration, so file notice of arbitration, arbitration commenced, respondent gives a response in a time that's determined by the institution, let's say 14 days under the SIC rules. What's interesting is we should actually have an additional dot right here, because what's become very common in all sets of institutional rules is that you have a lot of pre-constitution applications, these interlocutory applications. So after commencement, you could have the respondent might make a jurisdictional objection saying there's not a valid arbitration clause. You could have an application for expedited procedure. AIAC has their separate expedited rules, I think, which can be an advantage from a jurisdictional standpoint. But if it's under the main set of rules, maybe an application for expedited procedure. Maybe you need urgent relief. You have a ship stuck in port, the cargo is deteriorating, you need that ship out of port. Could be an application for the appointment of an emergency arbitrator. Consolidation, joinder, all of this is happening right there. So assuming you get all of these interlocutory applications done, the next big step for an institution is the appointment of arbitrators. Once the tribunal is up, standing, running the arbitration, the tribunal is the master of the arbitral proceedings. So now it's the parties, the tribunal. The institution has a bit less to do. So all the way up to the scrutiny of draft awards. So the scrutiny of awards at SIC is probably what I spend my most time on. I have a backpack that probably has 5 or 6 of them in my backpack right now. If I was to lose that, that would be very bad. So we do the scrutiny at the end. So most institutional work, very front-loaded. So at the front end, commencement, and then at the end for the review and transmission of the award. So SIC, we're in our 6th iteration of the SIC rules. The SIC rules 2016 was one of the most significant revisions to the rules, and these are some of the provisions that we brought in. Part of the reason for doing this, to keep up with best practice, we're also looking at some of these big project disputes that were going to be arising out of the Belt and Road, and then just the overall complexity of arbitrations that are being filed with really any institution. You might get a series of 5 contracts, 15 contracts, 50 contracts. If you don't have a provision where the parties can apply to have these all collapsed into one arbitration, it is going to be expensive and it is going to be time consuming. And of course, if you're around arbitration and if you are thinking about how a tribunal might be constituted, if you had, say, 5 arbitrations, every arbitration clause provided for a 3-member tribunal, and you were a respondent and you wanted to disrupt the arbitration, what would you do? So you have to nominate an arbitrator in 5 arbitrations. What do? You want this arbitration to take a long time, you want inconsistent decisions, you want it to be expensive for the claimant because you're not going to pay. What you would do, or maybe what I would do, is I would nominate a different arbitrator for each one of those 5 arbitrations. So with a 3-member tribunal, each side nominates 1 arbitrator. So claimant is probably going to nominate the same party-nominated arbitrator in 5 arbitrations. He wants these arbitrations heard together or collapsed in a consolidated proceeding. Respondent is going to nominate a different one. Now you have 5 separate references, inconsistent decisions, expensive. So now all the major institutions have these provisions for consolidation. You can apply to have all of these separate references collapse into a single reference. Joinder of additional parties, another important one. The SIC provisions on joinder are very broad, and so with both consolidation and joinder, SIC is effectively made a 2-step process. So prior to the constitution of the tribunal, you can apply to the SIC court for consolidation or for a party to be joined. After constitution, then the application is made to the tribunal. One of the most exciting provisions we have is the provision for early dismissal of claims and defenses. Effectively what this is the common law litigation features of summary dismissal, summary judgment, striking out that have been brought into arbitration. So I admire our candor when we quite openly say that we copied this from ICSID. Because if you're familiar with ICSID, Article 41(5) of ICSID provides for the early dismissal of a claim. So this is in the investment arbitration context. It has to be 30 days from the constitution of the tribunal. So what we wanted to do, we wanted to take away that time limit, so it's not confined by 30 days, and also make it possible to have the early dismissal of a defense. So there's, I think, around maybe 22 cases on early dismissal in investment arbitration. So the reason why we want to model it loosely on ICSID is because we wanted to have this body of jurisprudence where parties could look at how these cases have been decided in the investment context and then see if they could use it for commercial arbitration. So it's become quite popular. It's quite blue ocean in terms of how this is developing in commercial arbitration. Because for me, and I think particularly for civil law lawyers, because there's also early dismissal of a defense, I think people start feeling uncomfortable if you say that there is no good defense to this claim, that a tribunal summarily can say, no good defense, claimant wins. But it's really not like that though. The claimant still has to prove its case. Where you're going to have the early dismissal of the defense, you're going to be looking at it, say, on an affirmative defense. Or if you look at it from a striking out standpoint, say you had a respondent that had 15 heads of counterclaim, and 10 of those were squarely outside the 4 corners of the arbitration agreement. Instead of having to go all the way for, well, maybe a 10-month arbitration at AIC, they're very fast. Instead of having to go all the way for 18-month arbitration, 2-year arbitration, dealing with these counterclaims, you can apply to have those counterclaims struck out. So what's been interesting, I think, in terms of arbitration practice is that we're now seeing a change in how parties are dealing with their pleadings. So previously, if you were a respondent and you wanted to be difficult, you might just put in a very bare response to the notice of arbitration, just a 1-paragraph response denying all claims. Now you got to be a bit careful on that because a claimant could apply for early dismissal of your defense. So I think we're seeing a bit of a change. Parties will, at the very least, raise the specter of an application for early dismissal. I think that it made us feel quite good because now the other institutions are following along. ICC released clarification after we released this provision that, well, tribunals have this power, it's inherent within their case management power, so they've made that clear. I think Hong Kong, in their new draft rules, are going to include a provision on early dismissal. So this has been a very exciting provision because it's brand new in commercial arbitration. Within the revision, we also revised really some of the things that were just part of SIC practice. So most institutions are trying to look at how they can be more transparent, so we also now issue reasoned decisions on challenges to arbitrators. We also refined the timeline, so this is emergency arbitrator provisions. We made them even quicker so that I can continue not to enjoy my weekends. This part is actually true. If you see under the SIC rules 2013, 1 business day, because every weekend I'm practically working on emergency arbitration applications. Every Chinese New Year that I've been in Singapore, and that's 8 of them, we have had an application for the appointment of an emergency arbitrator every single time. So I said, there is no point having business day. We just need to make it 1 day because these applications come in on Friday night virtually all the time, or the eve of a holiday. And that kind of makes sense though, and this is why the emergency arbitrator appointments are so important, because if it is 10 p.m. on a Friday evening, you cannot go to court. If there was a call on a bond at 10 in the morning on Monday, your only option is to go to an emergency arbitrator. And I think SIC and all the institutions are doing it so quickly now. So if we get an application at 10 p.m. on Friday night, the president will decide the application. We'll probably have an emergency arbitrator appointed late Saturday morning, early Saturday afternoon. Emergency arbitrator will convene a preliminary conference, maybe issue a preliminary order, effectively a holding order, pending that call on the bond, and then we'll deal with the actual order once you've got that status quo preserved. So we've made it faster, also a bit more cost effective by having a fixed fee for the appointment of an emergency arbitrator. We have a fast track procedure as well, so we've increased really the ceiling for applications for this expedited procedure, which I'll show you in a few slides. So consolidation, as I was talking about, this is effectively how it works in practice. We'll keep with the example of 5 contracts, 5 arbitration clauses, so you can file a single notice of arbitration, and it's deemed to be an application for consolidation, or you can file 5 separate notices of arbitration and then file an application for consolidation. What's important here is that by commencing multiple arbitrations, while the SIC court is deciding on this application, you preserve the date of commencement. What will happen a lot, and it depends on the jurisdiction, certain jurisdictions the limitation on bringing a claim might be a couple of years. If you bring that application on 1 year, 355 days, and you also need to make a consolidation application, that can be a bit problematic. So you also lock in the date of commencement for the multiple proceedings. So this has been quite popular since it was released in 2016. We've had 107 of these applications, around 55 granted, so right around 50%. Joinder is quite interesting because if you look at the SIC provisions on joinder, you guys all know what joinder is. In terms of bringing in a party that was not originally a party to the arbitration. But what some of these joinder provisions do now is they bring in a non-signatory. So when you're making an application for joinder under the SIC rules, you can make an application on the basis that the additional party is prima facie bound. So not directly bound, doesn't have to be a signatory. You might be using, say, a principal agent theory for why this non-signatory should be bound by this arbitration agreement, or the parties can also agree. So, as I was saying, consolidation joinder, 2-stage application. You can make an application to the SIC court pre-constitution or to the tribunal post-constitution. This is the early dismissal. Excuse me. Bit of a slow start on early dismissal because it is such a new provision, but now we've had 10 of these applications and 3 of these applications have been granted. I think what's important when we were crafting the early dismissal, so we're taking away this 30-day time limit, which kind of makes early dismissal a bad name, but separate issue. So it's not confined by 30 days from the constitution of the tribunal. So what we needed to do was make a 2-stage test so that the application goes to the tribunal. The tribunal decides if it's going to proceed and then actually decides on the merits of the application. And you have to do this because if you don't have it sort of grounded in time, creative respondent will then make an application for early dismissal on the eve of a hearing, and now the tribunal has to hear it. If they don't, the respondent will be reserving, saying it was denied its right to be heard. So we had to have the safeguard of this 2-stage test. So the way you can apply for early dismissal of a claim or defense is on the basis that it's manifestly without legal merit or manifestly outside the jurisdiction of the tribunal. This manifest standard is kind of well, it can be a bit of a thorny issue, trying to decide what exactly is the manifest standard. So prima facie, I think everyone agrees, maybe is somewhere here, maybe good arguable case, say, on an application for interim measures, a bit higher, manifest standard. So I think the best articulation of the manifest standard is from Transglobal Petroleum and the Hashemite Kingdom of Jordan. So the tribunal in that case was talking about, so what is the characteristics of the objection? It needs to be something that can be determined clearly and obviously with reasonable dispatch. The exercise may be complicated, but it should never be difficult. So effectively what you're looking for in early dismissal, you're looking for a case where it's just a question of law, the facts aren't in dispute, and the tribunal is effectively asking the question, even if I believe your facts, is your claim still valid law? And that's sort of the standard for how you get an early dismissal. So like I said, 10 applications, 3 granted, but more importantly, I think the parties are starting to use and at least raise the specter of these provisions increasingly. Scrutiny of draft awards, so the major institutions that do it, ICC and SIIC, so AIAC has a technical review of the award. I think we might need to convene after to decide where the sort of lines are for that, because scrutiny, incredibly important, takes all kinds of time. So you get the tribunal, so the tribunal, after the hearing, closes the proceedings. First thing you need to do when you're really charged with having awards issued is you need to make the tribunal close the proceedings. So it's 45 days from the close of proceedings. Tribunal has to submit the award to the institution. We review it. It's a 2-stage process. So it goes first counsel, then to registrar or deputy registrar. We can approve, or then maybe go to the SIIC court. We try to turn these around in 2 to 3 weeks, and we're really trying to enhance the enforceability. We go a bit deeper into the substance, but I think the important point about scrutiny is that you're not trying to change the tribunal's mind. When you're reviewing an award, and I have, you can look at it and disagree entirely with the tribunal. So you could have a claimant that was substantially successful in all of its claims, a respondent that had been difficult and obstructionist the entire proceeding. Within the arbitration clause, it says that the losing party shall bear all the costs, and the tribunal might decide that each party is to bear its own costs. So then the comment would be, well, the transnational tradition is that costs follow the event, that the respondent should bear the claimant's costs, but that's really just for the tribunal's edification. It is not to change the tribunal's mind, and in that case, the tribunal decided that each side was to bear its own costs and didn't listen to our suggestion. Expedited procedure, so it's done in a variety of ways. So AIAC, separate set of rules, so you agree to that separately, run it under their fast track rules. SIIC, HKIAC, it's done by application. ICC now, automatic application based on the sum of dispute. So the expedited procedure, what it does is if you want an award 6 months from the constitution of the tribunal, you can apply on the basis that the sum of dispute is under 6 million Sing, which is around 4.5 million USD, I think. The parties can agree, or in cases of exceptional urgency. So this is really a procedure that has defined SIIC as an institution and really sort of established the ethos of the institution as having gold standard case management, but we're going to do it faster and quicker than everyone else. So you can see that there's an enormous amount of application. But expedited procedure is not without some controversy. SIIC had an award that was not enforced by the Shanghai Intermediate Court on the basis that the arbitration clause provided for 3 arbitrators, and SIIC president determined that a sole arbitrator is going to be appointed. The Shanghai Intermediate Court, which does get the sign-off of the Supreme People's Court, said no, party autonomy, this violates the party's autonomy, we're not enforcing. At the other end, there's a very strong Singapore decision in a case called AQC and ARA. It says that the SIIC president absolutely does have this authority, even if the arbitration clause provides for a 3-member tribunal. The parties have agreed to the SIIC rules. It says that the president can appoint a sole arbitrator in this specific circumstance of expedited procedure. So those are really the only 2 decisions on it. I think that the circumstances of the case in Shanghai were quite specific. We have had these same provisions enforced in other Chinese jurisdictions, but something to keep in mind in terms of how the institutions are doing expedited procedure. Emergency arbitration, we have 3 ongoing right now. We've had 82 applications for the appointment of an emergency arbitrator, so I think that is right around most in the world. What's important to understand here is that these effectively are just preserving the status quo. Normally they're going to be prohibitive injunctions, sometimes will be mandatory injunctions, but this is all reviewable. It's to preserve the status quo, urgent relief is needed, then you're going to get the tribunal that can hear the parties fully on this application. The tribunal can then discharge, vary, modify this emergency order. So it's just to hold things as they are until the constitution of the tribunal. We also have an arbitration protocol. So this is done with the Singapore International Mediation Center. Are you guys familiar with ARB-MED-ARB? We've also got MED-ARB, can be popular in Asia. So ARB-MED-ARB is when you start an arbitration, then it goes to mediation, then back to arbitration. MED-ARB, as the name would suggest, start with mediation, go to arbitration. The advantage of ARB-MED-ARB is, again, you're preserving the commencement of the arbitration. There is some academic arguments if you have mediation first, then arbitration, there might not be a dispute, so you could get into problems of enforceability. So the idea with this provision, you start an arbitration at SIC, we constitute the tribunal then stays the arbitration, parties go to mediation. If the parties are able to come to a mediated agreement, then they go back to the tribunal puts the mediated agreement into a consent award, and then you can leverage off the New York Convention and these 159 countries. If the parties can't agree, well, then you've got a standing tribunal and you can proceed with the arbitration. So this has started to get quite popular, particularly in jurisdictions where there's really a mediation culture and a culture of conciliation. Japan, I think, is the most obvious example of parties that really want to preserve long-standing business relationships without immediately going to arbitration. You guys have probably heard that there is now going to be a Singapore Convention for mediation. So you have the New York Convention for arbitration, Singapore Convention for mediation, where now these mediated agreements are now going to be enforceable in the signatory countries. So this is a really big development for dispute resolution. I think that sometimes people, when they hear about this, they think that arbitration, now maybe arbitration's time has come, the golden age of arbitration is over, but I mean, there's still advantages of arbitration, even with portability of mediated agreements that will continue to have it thrive. We have the SIC investment arbitration rules, so we're the first commercial institution to have bespoke, purpose-built investment arbitration rules. And that's really sort of the next stage for SIC, investor-state disputes involving states, intergovernmental organizations. And this was really happening because we were starting to get quite a few of these under our commercial rules. But what we wanted to do is we wanted to look at some of the complaints in investment arbitration and see what we could do with our commercial skills to make it a bit better. I think the most obvious complaint in investment arbitration is the jurisdictional skirmishes at the outset, the qualifying definitions of investment and investor. Months, sometimes years, so there's no objective criteria for the SIC investment arbitration rules. Save a lot of time. Appointment of arbitrators, I think the Allen and Overy studies showed that tribunals in investment arbitrations about 6 months to constitute. So we wanted to make those timelines quicker. So we haven't had a case under these SIC investment arbitration rules. We have looked at all of the different sets of rules, ICSID, PCA, Stockholm, I mean those are commercial rules, and tried to incorporate all the best practices to make investment arbitration more accessible, quicker, more cost effective. And SIC has been recently included in the Singapore and Sri Lanka FDA. That's a model clause, but so that's the easiest one to use if you're ever somehow in an arbitration, but of course lots of parties will draft customized clauses, but when in doubt, you always want to use the institutional model clause. These have been tried and tested in courts around the world. I have come to the point where I've seen so many notices of arbitration and so many arbitration clauses that if I see an arbitration clause longer than 1 page, I'm almost certain there will be a problem with it. It will end up being internally contradictory. You could have an arbitration clause that would be perfectly valid that says Singapore arbitration SIC, 3 words, that would be a valid arbitration clause for SIC arbitration. So model clause is the best. Be a bit careful about overly prescriptive arbitration clauses. The reason why these institutional rules have all of these features is so you don't have to set it out in your arbitration clause. Say with an expedited procedure, at the contracting stage, you don't know if it's going to be a $100 million dispute, a $100,000 dispute, whether you want it done quickly, whether you're a claimant or a respondent. Same thing with introducing, say, consolidation provisions in an arbitration clause, which you see. The institutional rules have these provisions there, so typically not a need to be overly prescriptive. How institutions calculate costs, everyone does it a bit different. I have to be a bit careful with AIAC sitting there because they are one of the most cost-effective institutions in the world, but we are almost as cost-effective. So we do it based on the sum dispute, so these are maximum caps. Some institutions will do an hourly rate for arbitrators, so so in SIC our default is capped, so if you have a $1 million dispute, the tribunal's fees would be capped, say at USD 60,000, institutions' fees capped at USD 8,000, and that's the maximum that you have to pay. Then what you need the institution to do is do the actual forensics on what's happened. What you don't want an institution to do is to have these maximum caps and say, well, it went to a final award 100% for the tribunal. Well, of course we'll give ourselves 100%. You want to look at what's actually happened in the case, how effective was the tribunal, how complicated was the case, how the institution performed, was there any delay occasioned by the institution? And so it may be the case, even with a final award, of these maximums, the tribunal might get 65%, institution might get 50%. So I'm a bit indoctrinated into the ad valorem process. I think it encourages efficiency, but parties are also able to agree on an hourly rate, which you might want to have, say, in very big disputes, because you don't want caps based on the sum of dispute. So this is really just to provide an indication. All disputes are different, but our average duration of case is around 14 months, median, which is typically a more robust indicator, a little under a year. The way I look at it, sole arbitrator tribunals, you can expect that in about a year. 3-member tribunals, maybe about 18 months, even though our data says 14 months. But I think what this does, it just shows an institution's priority on efficiency. To a certain degree, parties are entitled to have an inefficient arbitration if they want to pay for it. I had a very senior arbitrator come up to me and said that the parties have decided on 130 days of hearing. What should I do? Well, if the parties want to have 130 days of hearing, if the tribunal is able to, if it makes sense, then they can have an arbitration that goes on for 4 years. So when you're looking at all the institution with the cost studies, I think you just want to take it as an indication of the priority on speed and cost, so not how fast or exactly how expensive it would be for every arbitration. And of the major institutions, Hong Kong, London, Stockholm, SIC figures quite well in terms of its duration and its cost. So I think these are the fun slides. All the slides are easy now. All of the difficult law is over. Now it's just pictures. So SIC was growing to such a degree in 2013 we had to split from a board that was in charge of everything to now a board that's in charge of corporate governance, business development, overall operations. So effectively the company of SIC. You still have some arbitration luminaries on there, business leaders, Devinder Singh, one of the most revered dispute resolution counsel in Singapore, is the chairman. This is the body that really matters. If you're an arbitration fan, I think that all of them will look familiar. So the president is Gary Bourne, probably the most well-known arbitrator and arbitration counsel in the world. Devinder Bol, senior counsel in Singapore. Lucy Reed, very well-known arbitrator and arbitration counsel as well, who's now a professor. And so 22 of really the biggest arbitration superstars in the world. And what this has done, I think, is given SIC some international currency. So Gary Bourne's vision is that SIC is a global institution. We have one of the biggest caseloads in the world, second or third biggest, depending on how you judge. The quantum of our cases is big, but he wants us to be a global institution that just happens to be located in Singapore. And so what you get with this court is the most important procedural decisions in any arbitration is being made by the court. No matter how good that we think we are as a secretariat, this is the body that matters. So under the SIC rules, jurisdictional objections, joinder, consolidation, decisions on challenges to arbitrators. President appoints the arbitrators in consultation with the court. And then at the end of the arbitration, then we can consult with them on the review of an award. So if I'm approving an award and I want to, there's a very nuanced legal issue, I could compose a committee of Jan Paulson, Emmanuel Gaillard, and Bernard Hanenschel, three of the best in the world. I'll be a little bit more comfortable with that. What also happens a lot, because we have an active caseload of around 850 arbitration cases, is that we have a lot of ad hoc committees. So not just on sort of interpretations of the rules, just getting the Court of Arbitration to assist on any case management issue that arises. So this has been a really big advantage for SIC, and of course it's quite fun to have this Court of Arbitration with all of these arbitration luminaries. SIC has a public panel of arbitrators. I guess the takeaway for any institution, some are public, some are not public. Are you guys?
Yeah.
Public, that's right, yeah. So, but also an open panel. So not bound, so AIAC, SIC, HKIC, I think those are the main institutions that have a public panel, but these are open panels, so you can still nominate any arbitrator of your choosing. You're not bound to nominate someone from the panel. This just gives an idea of the growth of SIC from a very humble 2 cases in 1991 to to 452 cases in 2017, and most of those 421 administered some dispute, 4 billion USD. 2017, I think it was around 15 billion. In 2016, our top two foreign parties will almost always be India and China. This is based on a lot of factors, cultural connections, just where Singapore happens to be sitting almost equidistant. I think what's compelling is that how many European parties and American parties you're starting to see. So Switzerland, United States is perennially one of our top 5 users. And it sort of shows what is happening with global commerce, with the rise of the Asian institutions, because if you had American party, Indonesian party, American party may want a different institution in the first instance, Indonesian party may want BANI, so maybe ICBR and BANI. We don't see these negotiations, but that's how they're starting in the negotiations. They call the arbitration clause the midnight clause, because it's the last thing to be negotiated in a deal. The deal is already ready, and now we just have to figure this out quickly. And I think what happens with Singapore and SIC is it becomes everyone's favorite second choice. There are very few parties that are not open to arbitration at SIC. So that's where I think that SIC has really prospered, because it becomes that compromise choice that is agreeable to all parties. These are the types of disputes. Singapore is an island. I have a theory that every dispute at SIC has had something on a ship at some point. So a lot of international trade, commercial, maritime, and shipping. Singapore is the first or second biggest container port in the world. Construction and engineering, there are some very, very high quantum construction cases, but of course we get the whole gamut of disputes that we're able to administer. All the case management is run out of Singapore. We have overseas offices in Shanghai, Seoul, and 2 in India, in Mumbai, and in Gujarat, in Gift City. These overseas offices, no case management, but have been quite important to us in terms of being able to be on the ground with the users. So that's an introduction to SIC, Singapore arbitration, and I guess Asian arbitration. But I think both of us are probably happy to take any questions.
What do you think you should improve comparing to the best arbitration courts in London and Paris?
Sorry?
So what do you need to improve? What do you think you need to improve? What Singapore is lacking comparing to the best arbitration courts, I guess?
That's interesting. So, London and Paris have such a tradition of arbitration. So, in the recent Queen Mary White case study, Singapore is the 3rd most popular seat, SIC is the 3rd most popular institution. The fact that Singapore and SIC are already 3rd, is an incredible accomplishment, because ahead of historic seats, Geneva, Zurich, New York, Stockholm, Singapore ahead, if you believe that study. I think that what Singapore is very good at, and what we try to be good at SIC, is innovating and staying at the head of the curve. So bringing in provisions for third-party funding, this Singapore Convention for mediation, early dismissal. But all of these things take time for SIC, for AIAC, because a lot of these clauses are really historic legacy clauses. If you go and talk to, say, big users, and you ask them, what institution do you use? They will say some institution. Why do you use that institution? It's in the boilerplate. We always have. So a lot of times companies and users haven't really turned their minds to it. So if you were looking for Russian users tend to go to London. Would Russian users be equally and perhaps in equal stead, or perhaps better stead, to go to Kuala Lumpur, Hong Kong, or Singapore? I think so. It is going to be a very similar experience. It is going to be fast. You're going to be treated with fair dealing. I think that you get that in all of these jurisdictions. I think the parties are confident that they can come there and be treated fairly. So I think all of the Singapore, Kuala Lumpur, Hong Kong are rising, and the good thing is that they are willing to do things, and they do it very quickly.
Just to add up on something, it's also important to not forget the cultural element in all these countries. What works in Kuala Lumpur, for instance, for Malaysian companies may not work for Russian companies or Singaporean companies. And there are different scenarios of the development of all arbitral institutions. For instance, what makes our center unique in the appointment system is that we are trying to appoint more Malaysian arbitrators in the cases where we administer. And parties are also quite happy about it in many disputes, or sometimes they even ask precisely to appoint arbitrators with a background in Malaysian law, for instance. So to kind of maintain this cultural uniqueness, to give this opportunity not only to foreign arbitrators, although they can be very experienced and much more experienced than some Malaysian arbitrators. It's also important for the parties to know that, and for the legal community in Malaysia, for the arbitration community, to know that there are some opportunities for them in their home country.
Good evening, ladies and gentlemen. First of all, I'd like to thank both speakers for the extending overview of the Asian arbitration, because I guess it's even more interesting for us now, as due to the sanctions imposed in Russia, I guess more and more companies would opt for Asian arbitration, or at least they are likely to do so. So I would pose a question to the second speaker, if I could, that Singapore is now regarded as one of the safest arbitration centers in the world, maybe, that even the disputes from such old centers like Paris and London tend to shift to your center. And we've been speaking a lot about the rules and organization, but if I may ask you your personal opinion, what is the key of success of Singapore regarding the safety of this state? Thank you.
Just checking to make sure my personal opinion is the same as the institutional opinion. I actually think that it's the Singapore courts, because I think the institutional rules, if you're very honest with yourself, your experience at any of maybe 10 institutions is going to be quite similar. There's things that are a little bit different. What very few jurisdictions can match is the pro-arbitration Singapore courts. They are predictable. You know how they're going to interpret applications to set aside for enforcement. So for me, courts, and then maybe to a slightly lesser degree, as I was saying earlier, it's Singapore's ability to innovate and to do it faster than any jurisdiction that I've seen. Singapore sees something that is good and it incorporates it and gets it in the legislation almost immediately. I'm Canadian. Some of those things in Canada probably take 2 years to get that legislation on board.
Okay.
In your presentation, you mentioned the International Commercial Court in Singapore. Can you please tell me more about this? Is this the state court, and which disputes can be submitted to it? Is this recognizable abroad?
Yeah, so it's a division of the Singapore Supreme Court. So you can apply to have one of your arbitration-related applications heard by the Singapore International Commercial Court. And effectively, what it is a body of international jurists from around the world. I think it's very important in the arbitration context, because no matter how good a jurisdiction's court is, I think no one really likes if they're not from that home jurisdiction. So if you're going to a foreign jurisdiction, so the ability to have this international bench hear an application to set aside, hear an application for enforcement, interim measures in support of arbitration. And then you have parties, so not just arbitration, you have parties now in contracts that are agreeing that the Singapore International Commercial Court is the forum that's going to decide the disputes. It's taken a bit of time, so most disputes heard by the Singapore International Commercial Court have been referred from the Singapore Supreme Court, referred to the Singapore International Commercial Court. But interestingly, I think that the first SICC dispute where you actually had the SIC clause in a contract was recently heard. So there's been around 22, so I think it's a good additional option to have this body.
Thank you for the lecture. I have a question. There are some amendments in Russian legislation according to corporate disputes. So now only arbitration centers which have permission of Russian government may administrate corporate disputes. Do you know about that situation, and are your arbitration centers going to have this permission?
This was a question I was going to ask to my co-speaker. So this is something that we've been looking at quite closely because certain classes of corporate disputes, you would need to have an annex to your rules, so you would need to have a specific schedule. This otherwise affects Russian-seated arbitrations, I think, a bit more. So in our cases with Russian parties, these have typically been Singapore-seated, but we have publicly said quite a few times we're, I guess, past 1 November 2017, but it's not, sorry, yeah. And so, because I know that, I don't want to say, sorry, please. So have you guys applied? Because my understanding is that you have.
Yeah, we were planning to apply actually. So the amendments were introduced in November 2016, and a few institutions, including STC and HKC and ourselves at that time, PLRC, we already prepared the full set of registration documents, and we were about to apply for the council on arbitration. But at the end of the day, there was still no procedure for foreign arbitral institutions to register in Russia. Because the act itself provides that, foreign arbitral institutions, they need to have this permission. So the procedure is that initially you apply to the Council on Arbitration, then the Council recommends or doesn't recommend this institution to be registered in Russia to the Minister of Justice, and then the Minister of Justice decides. But still, there is a gap there. We're all looking forward to this registration, but on the legislative level, there is still some work to be done. That's why it's kind of problematic now. But most probably it will be the same regime as for foreign branches of foreign companies or foreign entities in Russia when you register a branch with the Ministry of Justice, the Tax Inspectorate, and all governmental authorities here. And therefore you will have to submit annual reports, tax reports on the annual basis, disclose some information, and disclosure is one of the reasons why foreign arbitral institutions hesitate actually to apply for the registration. So there are many issues involved, and so far everyone discusses or about to apply, but there is no progress.
EIAC? They have an application.
We prepared the full set of application documents. The problem is that there is no.
No, because it was you guys at DIAC initially. It was publicly the board.
Vienna International
Because I think Stockholm, ICC, LCI said we're not going to apply for various reasons, because you have to do this in so many jurisdictions. I think SIC took the middle ground where we said we're looking at it closely, which we were and which we are, because I think Russia is an important jurisdiction. So do you know the status of DIAC still?
Still we haven't applied because there is no no sense to apply at this stage. We are waiting for the next set of amendments. If I'm not mistaken, they are about to be presented or introduced next year. So if there is a procedure, if everything is very clear for foreign arbitral institutions, then most probably we will be applying, but still, yeah.
Any further questions? Well, if there are no further questions, thank you very much for the lecture. It was very interesting.